The next case is Muka versus Muka. Looks like we only have the appellant here. The appellee brief was filed by an attorney. That attorney has withdrawn, and the pro se appellee is not present. You'll have 15 minutes to present your argument. The argument is being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names, like I just said, of children, minors, or victims during your argument, but you can refer to them by terms like the children or initials. We've read the briefs and we're prepared to proceed when you are.
Thank you, Your Honors. May it please the court, we're here today on the first case under case number 31212 on a very limited scope issue on a post-decree contempt finding where the appellant appeared for the hearing, argued an impossibility to comply defense, submitted what financials he could at that time based on the necessary timing for taxes, filed the objections to the magistrate's decision timely submitted his precipice to the court reporter, and then due to some inadvertent error between the court reporter and counsel, a deposit was never requested nor submitted to counsel for payment, and the court sua sponte then dismissed that precipice and dismissed the objections. Your Honors, the issue on that narrow scope I think is relatively easy for review. It's whether or not the trial court abused its discretion in doing so. Under the trial court's local rule and under Civil Rule 53, the appellant complied with all of his obligations, satisfied all of those issues, and then due to some inadvertent error that's not accounted for in either the local rule, the appellate rules, or the civil rules, or in any actually written authority, they were dismissed. So,
and let me ask you, I kind
sure,
of go through the record, and I don't see anything after the filing of the precipice directed from the court to say, here's an amount owed or anything like that, until the court rules to say, I'm denying the objection because there's no transfer file.
Correct.
There's on the record, and I didn't see it, there's no specific communication saying pay this amount, do this.
That is correct. So the next thing on the record that would address that was the unopposed motion to vacate that appellant filed. What had occurred is when the precipice was ordered, there was a phone conversation between counsel and the court reporter. That conversation was reduced to a writing via email prior to the motion to vacate being filed. That was delivered to the court reporter. No response was ever provided. And then upon notice sua sponte of the dismissal of the precipice and the dismissal of the objections, that communication was filed with the motion to vacate.
So, and again, that was all attached to the motion. So
correct.
That summary of what counsel below said happened is attached to that motion to vacate.
Correct. So that's the only thing in the record that addresses it, because any communications or any interactions other than the precipice itself wouldn't have been in the record.
I think the local rule talked about there being some form of a deposit made for the transcript. Was any deposit made initially?
There was not. So if the court reviews the motion to vacate and the email communication that was attached there too, the communication between the court reporter and counsel at the time was, we'd like to order this recording, and the court reporter says, I'm really backed up. I understand, no problem. It's going to be at least a couple months, no rush. The decision is stayed pending the objections anyway.
So typically we have a court reporter that when it was filed doesn't know how much it's going to cost. So let's say it's going to be $2,000. So it's from what the emails are saying anyway. There's a specific amount asked for, so nothing was given to the court or the court report at that point in time.
Correct. So the appellant was waiting for the deposit amount to be given to pay. Upon notice, well, I shouldn't even say notice, upon the dismissal of the precipice and the immediate dismissal of the objections, communications were had with the court reporter. That motion to vacate was filed thereafter to demonstrate the fact that at the time of filing the precipice and ordering the transcript, the communications were, the court reporter is several cases behind. I don't have access to the recording. I couldn't tell you how long the recording is or how many days it was or how much it would be. So the appellant was in a holding pattern pending some communication from the court reporter, which based on the conversation, it wasn't shocking that it had been several months.
And if you didn't talk about this much in brief, I don't recall at any rate. Did the court rule on the motion to vacate?
I believe it did, Your Honor. I believe it was denied. I would have to double check because it wasn't a separate assignment of error in the brief.
That's okay. Then you don't recall off the top of your head the basis for that denial? Did it get into this issue of the transcript or not?
No, I believe that, if I'm correct, Your Honor, in recalling, I believe it was a short 1 to 2 page order just saying the motion was denied. But I may be incorrect, so I would double check on that.
We'll check the record, thank you.
The issue procedurally, Your Honors, other than that factual timeline, is relatively straightforward. Under the local rule, I agree the deposit should have been paid without knowing what the deposit was. There's nothing to be paid. Under the holdings of the 11th districts, however, for the trial court to reject a objection that's timely filed with a timely submitted precipice, it's reversible error on its face, because under 53, the trial court has to conduct the de novo review of independent review of the magistrate's decision. That was not done here. None of the merits of the appellant's claims were addressed. None of the arguments addressing whether or not he could afford to pay these support amounts, the fact that the underlying divorce decree was on appeal to this case, and the fact that the appellant submitted bank statements, credit card statements, and everything that he could submit at the time of the hearing because of the short turnaround. So the parties were divorced on December 29th, 2022. The trial occurred at the end of 2023 before any time of tax returns, corporate or individual, could be prepared. So the only thing the appellant had to submit was bank statements and his testimony. The testimony at the hearing was that following COVID, my client, the appellant, who is self-employed as a wine distributor, it's just him, it's a small business. He loads boxes of wine into a truck, drives around, delivers them to restaurants, and he hasn't been able to make similar income to what he was making during the marriage. None of those issues were addressed by the trial court. It was simply a procedural dismissed, too bad, you don't get your day in court, and the appellant contends that that's error on its face, Your Honors. I would point the court to Calhoun, as cited in the appellant's brief, that website being the 2024 Ohio 319. In that case, the court found that if a transcript is unavailable for review on objections, and it's not at the fault of the appellant, then the decision rejecting or adopting the magistrate's decision should be overruled. Under Calhoun, we contend that's a similar enough set of facts that it should be persuasive in this case, because, as I stated, the appellant complied with all of his obligations, satisfied every step of Civil Rule 53 and the local rule to comply, and it wasn't until the court sua sponte dismissed that all of a sudden we said, oh, there's been an error, and now we have to correct it, and that's how we do it.
Would seem to me there would be a clear error if at some point the court had said it's going to be $2,500 for the transcript, and your client or the party below just refused to pay that.
A clear error on the
that would
appellant,
fit
yes.
on Calhoun. That would be the fault of the party
Correct.
requesting the transcript.
Correct.
I'm not sure it fits quite into Calhoun. I guess it depends upon whether or not we feel you're below, you had a fair opportunity to know what you're supposed to pay and had paid.
Correct. And so that's part of the reason why the motion to vacate was filed, is because the appellant knew the record was silent on these issues, and we wanted to get into the record a motion with some evidence saying exactly what occurred. The appellee, who I believe at the time was still represented by counsel, did not oppose or respond to that motion to vacate. The trial court did not issue any orders addressing the claims in the motion to vacate. No one has actually refuted what occurred regarding ordering the transcript. Instead, my client's claims were just dismissed, and then by adopting the decision, he was found in contempt, ordered to pay attorney's fees, and ordered to purge by repaying the support amounts that he had already testified he couldn't pay. So that's the issue. I understand with Calhoun it's a little different, but it goes to the fact that in Calhoun, when the deposit wasn't paid, there was other issues, and because it wasn't on the appellant in this case, I think it was persuasive as far as rejecting them at the trial court's order. The other issues, Your Honor, as going to the contempt and attorney's fees on the merits on the second assignment of error, goes simply to the impossibility defense. It's well established an inability to pay is a defense to contempt in domestic relations court. It's also well established that if a party can demonstrate through financial means that they don't have the means to pay, that suffices, or that sufficiently demonstrates the preponderance of the evidence standard for an inability to pay. And in addition to that, it's also established in Ohio that on a very technical issue in domestic relations court, you don't need to have a finding of contempt. Even if the trial court had rejected the preliminary objections, dismissed the precipice as being unpaid, and then found, okay, the appellant's in contempt, sure, but under the merits, we're not going to have a finding of contempt because he's unable, that would at least be a different story, but none of those issues were addressed by the trial court. and we contend that to be an abuse of discretion because nothing was considered. So I know on this very narrow issue on this appeal, if there are no further questions, I would leave it to the issues that have been briefed, and to the point that the appellee's brief that was filed, though not argued, does not cite to the record in any manner. We would request that that brief be rejected under Appellate Rule 16A.
Any questions? No.
Thank you, Your Honors.
Thank you. Thank you for your presentation. The court will take this matter under advisement and issue a ruling in due course. Also, the clerk of courts will mail you a copy of the decision on the day it's released, and the opinions are posted on the Ohio Supreme Court website.